and we're all set. So as you may or may not know, I am Kimberly Banks Fawcett from Inspired Capital Group. I've been in real estate for forever. Grew up in a real estate and general contracting family, and then bought my first rental property 3 months out of college, just because I guess I would say it's kind of all I knew. I mean, I did get a business degree in college. I majored in finance and marketing, but I don't think I ever really had the intention to work for somebody else. Later on, when I tried to work for somebody else, it didn't go all that well. I'm not meant for corporate America. I have too many opinions. It might not be the opinions. It might be the faces I make when someone's saying something stupid. So anyway, I started, as I said, I started being a landlord, and then eventually you realize being a landlord is tough. Very not glamorous, and not a wonderful position to be in at 3 o'clock in the morning when someone's toilet explodes. And I went to a RIA and listened to a presentation about how you can be a lien lord instead of a landlord, and I was hooked. So I started note investing probably end of 2012, and went full time by the end of 2013. So that's what I do solo now. I do a couple of things on the side. We have an apartment building that we are currently selling. And we'll 1031 into something else commercial, but probably not multi-family because things are getting really pricey. And then I do some direct REOs from time to time, maybe a fix and flip here and there, but it's pretty much predominantly notes. And in my notes business, I prefer mods. Obviously, you get a little bit of both no matter what you do. No exit strategy is a guarantee when you're buying the note. Even if your ROI tells you which scenario will be the best, you get what you get, because you have to work it out with the borrower and all of that, as you all know. So that's my long spiel into who I am. So tonight we're going to talk about top 10 tips to keep your notes business out of legal trouble. It's not 10 tips on how to make your business go better or to make yourself more efficient or more productive or anything like that. It is solely focusing on mistakes you might make that could cause you some legal headaches. Will they be legal headaches that you end up in prison? No, not necessarily, but it's no fun being sued. A lot of people say in the notes business, it's not if you're going to be sued, it's when you're going to be sued. You're dealing with borrowers who either for purely natural reasons don't want to leave their house, or because they're running some type of scam and trying to live for free. But you have people that are litigious, and you are foreclosing on them also being litigious, and they're going to find ways to slow it down. So some of the legal things that I'm talking about are purely not necessarily errors, but things that you can do that might give a borrower more of a chance to slow things down. So keep that in mind as we're going along. But as everything, there is a disclaimer. This is most definitely not legal or accounting advice. I am not a lawyer, I am not an accountant, and I do not play either of them on TV. My intent of this presentation is to just raise issues you may not have considered before. A lot of times when you're getting started in the note business, we have a lot of, well, what if type questions pop into our head. So I'm coming up with a few of those. And these are raised hoping you will discuss this with an appropriate professional that you have selected to guide you with your business. It doesn't make much sense if you have a lawyer in all of your states, but you never called them to ask them questions how things should operate. So I may raise an issue, but it's on you to find out the best way to address the issue and keep yourself in check. I think that makes sense. All right, top tip number one. We're going to start with don't spend your last dollar on the buy. A lot of times when we start in note investing, we are so eager to get our first deal in. So I've got 25 grand to spend, so I spend 25 grand on my note. Well, now what am I going to do to pay for legal if we go there? Or heaven forbid to even board the note. I've just put the whole 25 down on the investment. you're going to get yourself in a very tough situation there if you don't budget in your operating costs. Now, for more experienced note investors, you also have to think about where you're going to get the cash flow to work the deals for your investors. Now, your partners or your funding partners, it's hard if you've got 15, 20 deals going for different people and you need money suddenly to do a clean out, or your new attorney and you've picked up a new state. So let's say now you're doing Nevada. They want a little bit of a retainer because they haven't worked with you before. You've got to have cash for that as well. And you don't really want to come out of your pocket, if you can avoid it, to pay these costs for these different investments. So, I mean, the whole point of having JV partners is you're putting in the work and they're putting in the money. So what you need to think about is having them pre-fund some of the expenses. That way, say you've budgeted $3,000 for legal and $1,000 for, I don't know, servicing and boarding, and then another $1,000 for insurance for the entire time you're going to have it. Let's say it's really close to one of the coasts in Florida, so you need some flood coverage. That's going to keep your deals moving along. As those expenses come up, you're going to have the cash to pay them. You're not going to end up behind or with a vendor that won't do any work because you haven't paid them. You're going to keep everything in check, and then your investors won't have any complaints about how the deal is moving along. Obviously, if something comes up in the deal that, I don't know, one of the borrowers decides to be difficult, yes, your JV partner might have a complaint. But there's not going to be any complaints about how you personally have done all of the things that you need to do. Does that make sense? In addition, in my lead-in, I was talking about how you don't want to give your borrowers reason or additional reasons to raise problems in court. You certainly don't want to have your your investors having anything to complain about. It's not your fault that the borrower just went bankrupt, but it is your fault if you never pay your attorney and therefore they don't show up at the foreclosure hearing. That makes sense? Okay, on to tip number 9. Oh, by the way, the order of these tips, I did the best I could. I'm trying to go from fairly logical and not, gee, Kimberly, where did you ever come up with that, to some more specific possible issues that new people might possibly not have thought of. So that's my order from 10 to 1, but obviously I don't know. I don't live in anybody else's brain. It's enough fun in my own brain. So just if you're wondering where the order came from. All right, tip number 9, manage your note business and your personal SDIRA investments separately. For anybody that doesn't know that acronym, that's a self-directed IRA. I just actually got this question last week before the holiday. Someone was very confused by the fact that their servicer wanted them to open a separate account because they were investing in their own notes now with their IRA money. Well, as you probably all learned from Quest or NewView or whichever custodian you're using, you and your IRA have to be separate entities. Nothing that benefits you can be attached to your IRA, or it's a prohibited transaction. So what follows from that is your IRA cannot benefit from the business credit and relationships that you have built up in your note business. They can't be connected even through a vendor. Now, if you are, so ultimately, they cannot be in the same account, period, no ifs, ands, or buts. A servicer might not tell you that. I would hope that they would tell you that. Part of their job is to protect you from from making mistakes in your business. Obviously, it's no guarantee, but that's a pretty easy one for them to want to point out and show that they actually pay attention to you as a client. But if you are a person who is very conservative, you want to make sure everything is very clear. You don't want to raise any suspicion. It might make some sense to have your personal self-directed IRA investments at servicer A in that account, and then do all of your business at servicer B. Granted, depending on the size of your IRA, you might not have as much leverage if you're at one servicer with, say, 4 deals, and the other servicer you have 35. Obviously, the more deals, the more service you get, the more client you are to a servicer. But if you really want to be conservative, there's no more separate than 2 totally different companies, and the 2 companies never meet. I don't know what you do if they ever merge, but that's you can take care of that if that happens. So it's just something to consider. You have to keep them completely separate. I don't know that every note investor has really thought about that. Myself, I go even one step further. I have note friends invest my SDIRA. I don't even do my own. So I didn't hire a different servicer. I just hired a whole different investor. You just take care of it and we're going to be good. Doesn't mean I don't have to input and make suggestions, all of that. But I'm so far removed from the note investments in my SDIRA, it's almost like it's a totally different person. So again, something to consider. All right, tip 8. Don't contact the borrower before you own the note. And if you decide to not listen to that, if you really, really have to do it, be smart. When you are looking at a tape to consider buying some assets, you sign an NDA. That means a no disclosure agreement. There's also an NDA, non-compete clause in many of those. I'm getting my acronyms confused right now. And that means you're not going to, I don't know, look at the tape, find out that this one is for sale, but oh, hey, so-and-so, that broker, they're also selling it and they might sell it for cheaper. So now I'm going to go over there and I'm going to compete with them. Or you're going to take the tape and you're going to try and sell it to a third party. That's what the non-compete part is. But the non-disclosure part is protecting the sensitive information that's in the tape. If a borrower is being foreclosed on, the foreclosure process and the documents involved in that are recorded in the county records. It's public information. Some counties it's easier to find than others, but it's still public information. So for me to know that Betty Sue down the street is being foreclosed on, I can find that out. Anybody can find that out. That's not a big deal. In that moment, you do have the ability to walk down the street, knock on her door and say, hey, Betty Sue, found you on the foreclosure records. Can I help you keep your house? You can do that. But if Betty Sue is just late, there is no public information that provides that. It's in her credit report, but credit reports are not public. Sometimes they feel like all of your financial information is public, but it's really not, or at least not supposed to be. So for me to contact Betty Sue and say, hey, I see you haven't paid in the last 90 days, wondering if I can help you out, you have just violated your non-disclosure agreement because that was confidential information you promised not to disclose. You also, as an aside, you can't take that information and ask their neighbors about them. It would be probably would be okay if you wanted to ask them about Betty Sue because of the recorded foreclosure. You know, do you know, is she around a lot? Do you think she's staying in town? Is she taking good care of the house? If you wanted to try that, you probably would be fine. It sounds a little slimy to me, but you could. But you can't ask the neighbors, well, you know, she's late, and I think pretty soon we might be able to take her house from her. Do you think she'd be okay with that? Or is she going to fight me on it? Again, disclosing confidential information. You also can't call up a realtor in the area and say, hey, this note down the street, they're a couple of months late, and it's address 123 Main Street. Could you tell me how much you think it's worth? You've just disclosed confidential information again. All you can say to them is 123 Main Street. Are you familiar with it? Do you have any idea what the cost is? We've just been looking in the area, and that's a house that's interested us. That's okay. There are some people in the note space that will get a tape and send out postcards to all of the borrowers and say, hey, we're this nice, sweet third-party company that might be able to get you a loan mod. Are you interested? Do you think that's legal? I didn't say they made their own tape from the foreclosure records. I said they took tape, the seller sent them, and sent postcards to all the borrowers. We're going to do that. Going along with my if you must be smart, you wouldn't put your company name on there. You wouldn't put your company phone number on there. You wouldn't put your face on there. You'd probably put another phone number, maybe use another company's name. It's still, to me, I still think it's iffy. I am not recommending that at all. Yes, if you're like my business model, I want to have mods. So I could definitely benefit from knowing that on a tape of 50 assets, 30 of them are interested mods. They've actually said they want to. Granted, not everybody that says they want a mod follows through. But okay, so I want to buy these 30. Those other ones that are all going to foreclose, that's your problem. I would so benefit from that. But I don't play that way. I'm a rule follower, which was perfectly fine for me until I started raising another rule follower. That gets very annoying sometimes. But anyway, that's my point. So if you really, really, really want to try and go around the fact that you said you won't disclose anything, please be careful about it. Don't get yourself, at the very least, if you get caught doing that, you will be blacklisted from that seller. And depending on who the seller is, they will talk to as many other sellers as they can, and you won't have a note business anymore. Past that, they could sue you. I don't think you could go to jail for doing that. I don't think. But anyway, keep that in mind. Next, no pooling money. I think everybody knows that. You cannot take money from investor A and investor B and put them together. One gives you 50 and the other gives you 50, and now together you can buy a $100,000 note. You are not allowed to do that. That is in violation of SEC rules. There are many, in the note space, there are many lawyers that present on how to avoid getting in trouble with the SEC. That would be the first thing that they tell you. One deal, one investor, one JV agreement. You could buy 10 deals with that one investor. That's not pooling money. It's when it's two investors in one scenario. So now for the more experienced investors, the thing that I want to point out is there are some people out there that will pool money within a JV agreement and try not to let each individual investor know that it's pooled money. So since your JV agreements are all private documents, you don't have to record a JV agreement. Presumably, how would anyone ever find out? Well, that kind of goes back to when I was talking about giving some of your JV investors reasons to give you a hard time. Say a deal goes south. It was supposed to, you had predicted that the ROI would be 20%, but once you finally foreclosed and got into the property, you realized, I don't know, that there actually was no subfloor. Everybody, whoever was living there before was actually living on the dirt. Crazy example, but crazier things have happened. Or when you got inside, you realized every single wall in the place was infested with mold. You can handle mold in one room on a couple of walls, but the whole house. So your 20% ROI turns into both of you are going to lose 10 grand on this deal. Well, some investors, especially if they bought one deal and it's the first time with you, they're going to really take that against you, and they may sue you. And now this is another instance of you are not operating your business professionally. You've been pooling money. Now they'll bring the SEC to give you trouble. They could actually get you in trouble. They could just threaten to get you in trouble. Not a good plan. So even though the documents that might show that you are pooling money are private, don't do it. It's not worth the headache. If you have two investors that want to invest together, you can do it legally without putting together a huge hedge fund, private placement memorandum, 25 grand in costs, and all of that falderall. You just set up an LLC. And you and the two investors each own well, I guess that would be weird. Each own a third. I don't know what you're doing with the extra percentages. Rule followers always are worried about the change. But you can set it up so that you are all collectively owning the LLC, and then the LLC owns the asset. That's not pooling money. That's just setting up another venture. That is perfectly legal. It is a bit more of a headache to manage. You've got to do tax returns and maintain another company and yada, yada, yada. But it's not, it is a way to make this happen without actually behaving illegally. So tip number 6, you need to protect confidential and sensitive information. We talked a little bit about that when we were talking about going and talking to borrowers before you actually own the note. But you also come across a lot of information on your desk when you are buying assets. You get a tape, you get the soft, meaning online or emailed versions of the documents. You don't have the actual hard copies. And it has social security numbers. It has birth dates. It has how many years you've been at work and what somebody's manager's name is. There might be a copy of an actual paycheck. There's all kinds of sensitive information, and it is your job to keep that confidential. A lot of people get in trouble possibly with their employees not maintaining confidentiality. So I have an NDA agreement with all of, I have an assistant. I had an assistant before that. So this is my second one. Did an NDA with both of them. And basically it included everything that any NDA I have ever signed with a seller included. I can't just assume because they are my employee that they are following things I have agreed to. I want an agreement with them to my company that they're not going to be an issue. All I need is for my assistant to take somebody's social security number and go out and steal their identity and the drama. I don't need that. Of course, just having her sign that won't stop her from doing it. But at least, when someone comes after me, I'm like, I tried. We had the conversation. I have this paper. I promise. So this also extends to if you want to solicit more information about your borrowers when you're doing due diligence, there are different vendors that can provide you information from credit reports, but it's not your actual credit report. You might have heard the term TLO. I have no idea what TLO stands for, but they're a division of TransUnion, which is one of the 3 big credit bureaus. So you can get information to do skip tracing on your borrowers when you need to find them to figure out what they want to do, maybe sign a document, whatever. As you know, once they move out of the house, you have no idea where the heck they've gone. And that can give you information like where their brother lives and the fact that their mother lives down the street. And, they used to live in Georgia and it looks like they may have moved back to that address or whatever. But that is, again, confidential information. And you have to have a process in your office of how you're dealing with those documents before TLO will let you sign up and use their service. They want to make sure that you lock your file cabinet, you have a paper shredder, does the door to your office lock, is there a password on your computer, all of that. So even if you don't want to use TLO, just put that in the back of your mind as, as I'm developing all my processes and as I'm taking my current process that work pretty good and make them work even better, that's one that you should really be considering to make sure you've taken care of. All right, tip number 5, avoid dual tracking. Dual tracking is when you are talking to a borrower about a loan modification while you are also foreclosing on them. Now, it gets tricky as to when it's an issue because, as I think I even mentioned before, just because someone says they want a loan mod doesn't mean that they're ever actually going to follow through. I mean, you have a list of documents they've got to provide, and they've got to provide a paycheck and they've got to do this in the timely fashion and that in the timely fashion. Well, maybe they're just delaying everything so they have more free time in the house. It's possible. So you don't have to, as soon as they go, hey, I'd like a loan mod, stop everything that you're doing. But at some point, if you do not stop the foreclosure process, you are dual tracking. Now, the common thought is as soon as they have provided you everything that you have asked them for. To me, that gets a little sticky because What if, especially when you're a newer note investor, you've asked, the servicer asked for all of the things that they think you should have. But what if you want something extra? You've looked through the documents and something seems weird, so you want a little more information. Myself, I had a problem with one of my first mods where I was going through the application, and I was looking at the pay stubs that they gave me and the 1 year of tax return they gave me, and things just weren't, the numbers weren't jiving. It didn't seem like there really was enough income to go ahead and pay for the mod. But they insisted they had more money than that they had more money coming in. So I had to go back to the servicer, who had to go back to the borrower, and request another year's worth of tax returns. So had she provided everything we needed at first and I should have stopped the foreclosure? Or did we need to leave a little bit of time there for me to review and look through it? So there's a little weirdness in that space. So you should definitely check with your attorney in the state that you are currently foreclosing on where your issue is. They will give you the guidance as to when you are starting dual tracking. Obviously, you can also talk to your servicer too. But I specifically bring up the servicer because I did get in trouble for dual tracking one time. It was a house in Georgia that we were working on, and it was literally the last day before the foreclosure. So that would have been a Monday because, foreclosures happen on Tuesdays. And she finally sent in all of her documentation. And I said, okay, fine, we'll stop the foreclosure. We will review your documents and we'll see how we're going to do it. And I called my attorney, stop the foreclosure. We're talking to her about a mod. Well, the problem was my servicer did not tell her that. For all she knew, we were still foreclosing on her. I really think that is my servicer's fault. Later when I asked them, I said, what's the deal? Why didn't you talk to them? Well, we don't do outbound calls to tell things like that, and we always drop a letter in the mail so they have an official record. Well, yeah, but that doesn't help me on the day before the sale. If you had told me that you wouldn't let her know, I would have called her, or the attorney would have called her, and she would have found we wouldn't have had this problem. Well, that's not how we do it. Well, thank you. That you've been helpful. Not. So it's up to you whether you want to blame my servicer or blame me, whichever. I will never let myself be in that situation again. So. And what finally happened was there was also someone working with her on her second that she was delinquent on. And they realized, she explained to them, they're dual tracking me. I doubt she used the term. And so that person, that investor that was working on the second, told her to go to CFPB. And I got a CFPB violation for that. And I had to spend $250 with an attorney to write a response and explain that it was just a matter of the servicer's communications. I think they found a nicer way of saying that than blaming the servicer. But an explanation that it wasn't an issue, and it went away, a big deal. $150 to keep me out of court, I'll pay that pretty much any day of the week. But I found it annoying. I think it was the servicer's fault. It was their job to point out a system process that could cause issues. So you do with that comment what you'd like. Okay, so we've just done tip 5. Does anybody have any specific questions? A bunch of people have jumped in and said hello. Hello all. If you have some question about one of my slides or one of my topics, definitely jump in. I'd also love it if you jumped in and told me, A, that you're here. I have a number of how many people are here, and then I have a few names for people that have responded. But I would also love to hear where you guys are from. Since we do so many of these meetings online, a lot of times people aren't even in the area. There's no reason why you have to be in Dallas to watch me on a webinar. So that would be awesome. Hey, Howard. I would love that. So, all right, going on to tip number 4. Think twice. Maybe even 3 times, maybe even a couple more times before you speak directly with your borrowers. that comes for a whole bunch of different reasons. I realize the presentation is supposed to be legal, just about legal, but myself, there were two borrowers that I personally, when I started my notes business, and this was when I started my seconds investing. I do firsts and seconds and contract for deeds. And the reason why I regret reaching out to both of them is twofold. But they'll both make great examples for this presentation. Isn't that convenient? The first one, oh, by the way, it suddenly started pouring. So if you can't hear me, let me know and I'll turn down the air conditioning and hopefully turn up my microphone. So the first one, I talked to this man who his house was destroyed by a level 5 tornado. And when you buy a pool of seconds, you know, we knew what our price was ultimately, so we went backwards in our due diligence, and we started with like the most expensive ones and went down the tape. And then once we realized we were going to make our money on this pool, we didn't need to look as closely at the last few on the tape. Well, of course, this one was the last few on the tape. You know, when we looked on Zillow, the house looked great. It was this big 3,500 square foot house in a gorgeous neighborhood, tons of trees. This was going to be a slam dunk. Well, the only problem was, as you may have realized when you look at properties on Zillow, the picture was a year and a half old. The house was no longer there. So I didn't realize that until the servicer sent out the RESPA letter, and as soon as the guy got it, he immediately started calling to try and talk about his loan. And his basic issue was it was wiped out. He was severely injured in the storm. His whole family hid in the basement, and part of the basement was under their concrete porch out in the front of the house. Well, when the tornado literally tapped and moved it into the backyard, the concrete slab that was his porch landed in the basement, and it landed on him. He said it cost over $200,000 for him to learn how to swallow, how to walk, how to talk. I don't know if you can tell, but this was 2 years ago, and I still get a little choked up thinking about it. Because his first comment was, thank God it wasn't my kids. So the reason why he jumped so quickly to call was he had dealt with everything else tied to the house and gotten all of those bills paid off. But his second was trapped in that hedge fund vortex that can happen sometimes, where this hedge fund owns it, then they sell it to this one, who sells it to this one, who sells it to this one, and nobody ever records an assignment. They wait for the ultimate investor on the end, people like you and I, to go ahead and record all the assignments. So every time he looked in the file, he had no idea who owned his loan. So he was extremely excited to get the boring old RESPA letter to find out who it was. And you know, it even turned out okay. There was no house, and he sold the lot. So I bought the note for a little over $4,000, and he sold the lot for $25,000, and I took $20,000. So I made a $16,000 profit on a house that didn't even exist. So that example, think twice about talking to your borrower, because that borrower still gets me worked up. Imagine if I was trying to really, you know, be aggressive and make sure he pays, and I'm not going to give away any money and all that kind of stuff with a guy that tells me a story that can really get to me. I mean, clearly that's proof to me that once you start talking about your kids, I'm a little too soft-hearted to be able to have those conversations. I do not get choked up when my servicer calls and goes, okay, so she says she lost her job because of blah, blah, blah. That does not bother me at all. So that's one of the reasons why I have my servicer handle it. You just know who you are. My second person that I talked to personally, the reason why I regret that was one of the letters that I signed going out to him had the comment that all of us are trained to do if you're going to talk to your borrower about, you know, my company is a debt collector, and to, you know, consider that when you're talking to me and all of that. And he used that, as well as where it said that I, you know, signed my name and said manager, I hand wrote it as opposed to having it typed in the footer, whatever, directly below my signature. So therefore, it wasn't accurate that I had that title. So not only did he sue me for not being an actual licensed debt collector in his state, all I said was that I could be considered one, whatever. Then the lawsuit wasn't just against my company, Inspired Capital Group. It was against me personally, because he said that writing manager didn't count. So just from one letter, I got myself into hot water and extra things he could throw at me and all of that. It was, I think, so far, knock on wood, the only time I've been sued, and I hope I don't get sued again. It was not fun. But if I had just let the servicer do all of it, that would have never happened. And he still would have contested the foreclosure, and it still would have been annoying, and I probably wouldn't have made any money on that deal, but he wouldn't have scared the daylights out of me, suing me personally. So think twice, 3 times, maybe a dozen times before you talk to your borrower. Now, I see a question over here. Let's see. First, Chris Zimmer said that Gordon Moss, his strategy revolves around talking directly to the borrower. That is absolutely accurate. I believe he talks about it in his book, and he talks about it in all of his presentations. That is just a different business style. I think Gordon has been doing this for 20 or 30 years. If he has not figured out yet how to say everything he needs to say without getting himself into hot water, then he's got a problem. So that's A. And B, it's just a different business style. When he talks to someone about, and they mention their children getting crushed by a concrete slab, that may not get to him. Everybody has a different business. Personally, that's one of the things I love about the note business is I do it my way, you do it your way, he does it his way, she does it her way, and we're all happy and making money, and there's no problem. So yes, Chris, you're absolutely right. Gordon and I do not do it the same way. Let's see. Howard asks, what do you do if a borrower calls you? Well, I mean, you're perfectly polite. It's not a problem. You don't have to freak out. It's when you're discussing confidential information that you have to make sure your borrower is actually the right person. You check their social security number, all of that kind of stuff. But if they're like, hey, I'm Tom Smith and I live at 123 Main Street and I think you're my lender. Oh, hi, Mr. Smith, how are you doing? It's great talking to you. What's the weather like there? Whatever kind of chit chat you want to make. And you say, well, I wonder if you'd say note investor. Maybe you could. That might confuse the person. Whatever. I'm a note investor, and if you're one of my borrowers, that's fantastic. I hope we can, whatever's going on, I can help you with. But normally, my servicer talks to my borrowers. That's what they're equipped to handle. And let me get you their number, or give me your number, and I will have them call you immediately, or whatever. But I would definitely defer them right to the servicer. But Howard, if you want to talk to them directly, you talk to them directly. That's not a problem. What I would do if you really are thinking about talking to your borrowers is to make sure you take some training on investing in seconds. The reason why I say that is most seconds investors, which Chris, that is what Gordon Moss does. He doesn't have anything to do with firsts. Traditionally, seconds investors have always spoken to their borrowers. So they talk about, how the letters have to be written, what has to be signed where, how to do your own RESPAs, how to do your own TILA letters, what to do if they file bankruptcy, who you can talk to, who you can't talk to. And then they talk about a mini Miranda. Now, if you've heard the word Miranda before, that's the statement they have to read to you when you get arrested. But the mini Miranda that they talk about is all the information that you have to disclose to the person you're speaking with so that they know you are a debt collector. If you're going to be really thorough, very conservatively, there's also a line or two that you could say about bankruptcy. That particular section says basically, I promise that once I find out you are actually in bankruptcy, I will talk to your trustee or your attorney. I will stop pestering you. I'm sure it's said much more eloquently, though. And then both of those, your mini Mirandas also should appear in your written documents, as an aside. But seconds training is where you get trained on how to talk to borrowers without getting in trouble. They don't do that in the first realm. There's just, I'm not even sure why they don't do it. I mean, currently all of the big instructors for firsts note investing, don't do seconds. So they're not going to include it. I mean, I don't know if I get that. I mean, I realize if you are going to be a guru and you're going to bring in students, you have to be an expert on something. So it makes more sense for them to specialize. Me, I'm not trying to educate anybody. I'm not trying to bring in a whole bunch of clients that I can get an education fee for, so I can do what I want to do, and I can enjoy the fact that I like working on all different things and staying interested. So I don't know, if someday I suddenly decide to teach a class, I will even teach first investors how to talk to a borrower. But that's not the current model in the education world right now. So mini Miranda is the term that you're struggling to write down and wondering what it was I actually said. All right, tip number 3. Choose your words carefully, spoken and written. Oh, that kind of blended with the last one, didn't it? You need your mini Miranda. You also need to make sure that when you are talking to a borrower or to an investor, that the words that you say are actually what you mean. For example, the word secured or the word safe can get you in trouble. You and I know that these mortgages are secured by a house, which means the mortgage goes bad, I just take the house. But someone that isn't an experienced note investor won't necessarily know that when you threw the word secured out, that means you'll never, ever lose any money on this deal. See the nuance in the word? Well, everything was secured. That means it's safe. No. Just because the mortgage is secured, money can still be lost. I think you can also get yourself in trouble if you, like, sometimes I'm tempted to take that conversation one step further and say, I mean, yes, you could lose money, but you're not going to lose everything because there's always some value in the house. That can still get you in trouble too. What if, I don't know, it's such a low value house that you're actually at the point where it's worth more if you tear it down and just use I don't know. Again, back to the, if you're being neurotic and incredibly conservative and want to make sure no one ever takes the words that you said the wrong way and uses them against you, blah, blah. You see where I'm going. So you have to be careful what you say. In different communications, if you're going to advertise for funding partners or joint or JV partners, you have to make sure you don't say things like safe, guaranteed. Sometimes you can even get in trouble with annualized or cash on cash, because the way you calculate your returns is not necessarily the way everyone calculates their returns. And then if you say, well, if I take my 6-month return of 12%, that's an annualized 24% return. Well, yeah, if you had every dollar invested again for the next 6 months and you were able to duplicate blah, 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 blah. All of that lawyer speak that can really bore the heck out of a person. But it's true. It's a nuance. It's a hole you left open that someone could walk through and cause you troubles. So choose your words very carefully. Now, on the borrower side, you have to be careful if you talk to them and you threaten them. I mean, I'm not talking like, I'm going to show up at your house and I'm going to make you pay or else, not those kind of threats. But things like, well, if you don't pay me by today, I'm going to come and board up your house. It'll be my house then. How are you going to get in? You can't say that. You can't say, well, if you're not going to pay me or you're not going to return my calls, I'm going to go find your boss and tell him all about your legal troubles. No, that's just stupid. I think that problem known investors get themselves into much, much less than the, it's safe, it's fully secured problem with a JV investor. But you never know. Many people also say when you're talking to a borrower, you shouldn't threaten to foreclose if you're never going to do it. I don't think that's going to get you in legal trouble. If I'm sitting here and I know, I don't know, I don't have the stomach to foreclose. I don't know if there are many investors that can't do that. I guess someone else could have a sensitivity to children and don't want them on the street. Did I just admit that I can put children on the street? I don't think that's where I was going at that point, but you know what I mean. But say you know there's a problem with the paperwork, like you know you don't have a copy of the note. Well, then you probably can't foreclose. So you threaten to do it and then you don't follow through on your threat. Well, you're allowed to change your mind. So I don't think you can get yourself in legal trouble for that. You've lost your negotiating stance with that borrower, though. If somebody tells me they're going to foreclose on me and 6 months later they still haven't, I'm not going to ever believe anything they say again. But the point of my presentation was legal trouble. So if you want your borrowers to believe you are actually going to proceed, you have to proceed. So that's not really watching your words. That's just not being, what's a good word to say? Not being trying to think of a good noun that is able to be used in a recorded webinar. How about not being a wuss? Anyway. Tip number 2, don't be cheap. You are not qualified to do it all yourself. Do not take other people's legal documents and cut and paste and make your own legal documents. Not your JV agreement, not your modification agreement, not your, I wouldn't even do it if you're sending out your own RESPA letters. Don't copy somebody else's. You need an attorney to review these. You may be looking at someone's document that was done in Ohio, but you live in Florida, so they're not the same laws. You may be using a document from someone that says they've been doing this business for the last 20 years, and they really just started 6 months ago actually ever doing anything, and their idiot brother that still lives in the basement just took it off of legal Zoom or whatever those fill in the blank documents are and just figured out how he thought it would. You have no idea of the quality of these documents. I don't care how many times they've been used. I've seen note investors that have been doing this for a dozen years, and maybe the original template they had for their agreements was okay, but A, they haven't had it reviewed in years, so laws do change, you know, and B, they have futzed around making changes, you know, accommodating this borrower and then putting in this borrower's name, and then, oh, well, we do have 2 entities, so that entity's name. And it's so obvious that it's never even been proofread, and now you're taking it and trying to make it a document of your own. All to save a little money. The money that you will save by having a lawyer review your documents before you give them to someone and rely on them to be able to protect your interest in your investments. Really? You're going to cheap out on that? What would that cost you? I think my attorney, the last time I had him look at my JV agreement, he charged me $750. I mean, I had an agreement and he looked at it and he didn't find any problems. They always have to change something. I don't know if you know that, but that's like in the legal, that's also in the auditor's books. They have to find something. Therefore, their job, they've just justified the fact that they exist. So they will find something. Okay, fine, we can reword that paragraph if that makes you really happy. But, you know, it was a document and we could work with it. So that was fine. You are allowed to do that. You can take somebody's document and have your attorney do their own review to make sure it's okay. So it doesn't have to cost you $5 grand for them to make you a whole slate of documents to run your business. But don't cheap out on $750. You could not pay that $750, do the deal, and end up losing 20 grand. Wouldn't it have been better if you had made sure that that one extra clause actually appeared and that it was, I don't know, separated by commas instead of semicolons, so now it actually protects you? Stranger things have happened in different documents. So that's my tip on that one. And our final tip of the evening, tip number 1. Do your due diligence, all of it, every single time. The more notes you do, the more notes you do through time so that your stable of exited deals gets larger and larger. And the more notes you look at day to day, I think the easier it is to sometimes let things slip by. For example, you're doing due diligence on 10 notes and you order 10 O&Es, but for some bizarre reason you only order 9 BPOs. That one would be easy to catch because once you sit down to really finely analyze that note, you're like, where the heck is my BPO? You're going to see that. But what if 10 of them you check the parcel numbers on the O&E and the BPO to make sure they match what you looked up for that actual asset. And you only remember to check 9 of them, and one of them's wrong. Well, they're usually right. The last 75 notes I looked at, they were all right. It doesn't matter. I thought, well, no, that's going to be the one that causes you a problem. I bring that up specifically because I'm working on a pool, and I had 2 notes today spectacularly fall apart on me. I was really excited about these 2 notes. The first one was in Cincinnati, and it took a lot of time for me to wrap my brain around the vesting of this particular property because it was 2 women and a man that owned it. It started with the 2 women, and they each shared, it would be like, I'm Kimberly Banks Fawcett. So it would be Kimberly Banks Fawcett and Linda Banks. Okay, so we are probably related in our maiden family, and I got married. Okay, well then it said Linda, the next iteration on the mortgage, it said that Linda Banks, in parentheses, a married woman. Okay, so Banks is not her maiden name, that is her married name. Okay, so they're either mother-in-law and daughter-in-law or 2 sisters-in-law, right? Anyway, then you add in the husband, and his last name is the same name as the first woman, so I really think it's his mother. Why the mother would add her daughter-in-law to a house before she added her son-in-law to the house, I have no idea, but that took a while to figure out. Anyway, the big problem with the loan was he was not on the mortgage. So he's on the deed. All 3 of them are on the deed, but only the 2 ladies are on the mortgage. Signed the mortgage saying, I acknowledge this agreement. This literally said under his signature, I acknowledge this agreement, but I will not be responsible for the debt. And he is not on the note, and he has not signed the note. So at least the debt part corresponds with what's going on with the note. The problem is he lives in Ohio, and Ohio, believe it or not, learned this today. After you've been investing in Ohio for a while, you'd think you'd already know this, but I guess it's pretty rare for just a married woman or a married man to be the only name on the deed nowadays. But anyway, they have a dower interest. Dower as in short for dowry. So because she owns that house and he is her husband, he is entitled to 50% of what she owns. It's kind of like community property in other states, but they want to call it a dowry, whatever. So when he signed that document, because his name was not on the mortgage, so he was not a part of the lien on the house at all, legally a part of it, his signature down there just gave away his dowry interest, but it did not give the originating bank permission to ever foreclose him out of that house because he was not on the mortgage. He was not on the document that tied the lien to the house. So that means I buy that loan and I have to go ahead and foreclose, and I'm only ever going to get 2/3 of the value of the house. I don't know what I'm supposed to do with this random guy who may or may not be hated by his mother. I don't know, whatever. So obviously that deal is dead. Then the second one, from the same pool, by the way. It's in Delray Beach, Florida, and the woman's first name is unusual, lots of vowels, and her name appears in the mortgage and the note and the deed 3 different ways. So it would be like, let's use the name Lara. It would be Lara, Laura, and Lori. Each document had a different first name. Then the addresses in the documents, the name of the street, an M as in Mary, and an N as in Nancy were switched. So in some documents, the street name had an N in it, and some documents, the street name had an M in it. The house numbers were 123 and 321 in different documents with different street spellings. And if that's not enough, the legal description of the properties was different in multiple documents. Oh, and the parcel numbers, while correct, while they always went with the proper street name and proper house number, the two parcel numbers were only off 1 digit. So you know how there's like 12 numbers in a row? The first one ended with a 1 and the second one ended with a 2. All the previous 14 digits exactly the same. Those documents are so confused that it is ludicrous. My assistant and I sat there, pushed papers back and forth. It was probably a half an hour before we started the meetup, and literally we could not figure out who was who, what was what, who went what house. So we booked a conference room tomorrow with multiple whiteboards on it, and we're going to map and probably, draw lines and cross things out and which document has which ad to figure it out. My attorney reviewed the due diligence file. By the way, that's an aside. Just because you're really good at due diligence, have your attorney look it over. A lot of people have their collateral custodian look it over. The two big ones being Richmond Monroe and Orion. They're not that good at it. They're not as good as a local attorney. And local attorneys don't charge that much for it. But I guarantee you, on the first one, I would have never known. I didn't know about the dower interest in general, but the fact that him signing didn't actually make it so I could foreclose, I would have never put up with that, figured that out. Would have never put that together on my own. And then on this Delray Beach one, I did notice the N and the M, but I just assumed it was a spelling error, and I moved on. I didn't check. Then I did notice that in one document she had her middle initial, and in the other document she didn't. But I didn't notice that it was Lara, Laura, and Lori. I didn't notice that, and I didn't notice it was 123 and 321. It's just, oh, of course, I never compared all 15 digits of the parcel number. I don't care how many notes I've done. That would have been impossible to notice, and my attorney found it. So you definitely have to get your attorney looking at these files. Just because you might be interested, he said that this particular file can be foreclosed on. It could be worked out, but she's already been contesting the foreclosure for a year. So even though I've saved time by already getting it into court and not having to have a demand letter out there and wait the month and blah blah blah, all of that, she's going to fight me on everything. And if the bank already screwed up that many things when they originated the loan, I have confidence that everything else is good. In addition, there is a separate lawsuit going on to try and figure out who actually has title to which house. They have to figure that out before they decide if they want to allow the lender to take one of them back. Or both of them maybe, who knows? The other lender could be a part of that lawsuit. Cool things, isn't it? Mix up the houses and figure out which lender belongs to which one of them. So I think that would, I don't know if you've all heard me present other times. I kind of like notes that are just crazy and would be a very interesting case study, and we'll have something to talk about for forever. So at the right price, I won't shy away from this note. I just don't think the seller is going to take a $25,000 fade. But I'm not doing it if he doesn't. So we'll see where it goes. It will also be interesting afterwards if I do walk away from the deal because he won't lower his price. to follow up in a month, 2 months, and check county records to see if an assignment has been recorded. Because that means I know for a fact that this seller knew there was a problem, because I will make a case for the issue, knew for a fact that there was a problem and still was willing to sell it to an unsuspecting known investor who never got their attorney to look at the thing. Thanks, Paula. Crazy Notes seem to like you. Well, they just find the people that are capable of handling the crazy. Let's do it that way. Let's just assume whatever. They're seeking their own solution. Anyway, but it would, I have not bought from this seller before, so it will be nice to find out if he is, if they're good guys. There are sellers out there that figure, there's tons of newbies coming along. I don't care if I piss you off. Next time I'll just sell to somebody else. Other people want to actually have relationships with their buyers and continue to work together, and you don't have to keep going out and finding new buyers and working things through and finding out if they close and yada yada yada. Everybody has a different business model, so they may still sell it. Who knows? We'll see. I really hope they don't though, but whatever. Anyway, it's Florida, so it'll go for a lot of money. Oops. Hey, we went up. That's weird. All right. How to reach me if you need me? Because you want to. Obviously, the last one, you're already part of this group because you joined me this evening. Oh, question. What about reps and warrants on your PSA, your purchase, your sales agreement? That can help. Obviously, it's something you would always like to have. What that means is when you buy the note from your seller, they are representing and warranting that it is a legal, yes, it is a legal lien in whatever position it is you're buying it as. So if you're buying a first, it is a legal first. If you're buying a second, it is a legal second. I have had a number of seconds that I bought that actually, once I got into the deal, realized they were really firsts. Obviously, I'm not going back to my seller for that. I'd much rather pay a second's price for a first note. Thank you very much. Anyway, but that's obviously going to be a problem for you if you think it's a first. You paid for a first and you only have a second or a third. So yes, I think if we hadn't noticed that Laura, I got to start with the Lori was convoluted and the address numbers didn't match and all of that, I believe most reputable sellers would let me cash that back in because of their reps and warrants on their agreement. That does get sticky though, Dave, because okay, I bought the note. Let's say I bought it for 50. Actually, my accepted bid was 58 on this one, and I want to pay 38 if I take the crazy. So let's say it closed at 58 and I hadn't noticed the problem. Well, that means I now have a $58,000 credit with the seller. It's going to be very rare that they're going to write you a check. Now, let me say as a caveat, I've had to return a few seconds in my career. I've never had to return a first. But with seconds, even though this one was worth 10,000, this one was worth 15,000, you're still not going to get them to write you a check. What they want you to do is they want to either flip you a deal, which they get to pick off of their pool and tell you what the price is and see if you want to take it, or they just hold it as a credit until you find something else to buy from them. Well, if they already have crazy product. So these two notes were crazy, and I know another investor working on this pool that had 4 that were crazy in this pool. How many of them are crazy? Maybe they bought it from a crazy bank. I don't know. I'm not sure. What if they're not only this whole tape is crazy, but what if all their tapes are crazy? What if they always somehow end up with the junk that nobody can do anything with? I'm going to wait 2 years with them holding a $50,000 credit for me until I can find one that's not going to be insane and actually make me some money. I mean, that's a nightmare. So yes, I do agree, Dave, that reps and warrants, you absolutely have to have that in your loan sale agreement, but it's not the perfect solution. I actually have a second that I need a hedge fund to swap out for me. And I have emails where the head of the hedge fund said, I will absolutely just refund your money because yes, you're right. Going through 15 different loans that are not very good just to try and get rid of you and this credit hasn't worked. But that email was 2 years ago, and now I can't get him to answer my calls, and I'm having to hire an attorney to get him to give me back my 10 grand. To the attorney. Like, it's not a fun place to be. So my reps and warrants on that particular, nope, really not going to do much for me. So we'll see. Anyway, so yeah. But anyway, this is how to get a hold of me. Back to what I was saying. That's my email address. You can obviously also contact me through Meetup. I don't necessarily jump on Meetup until we're getting ready to do a Meetup. So that's a little tougher. You can always find me on Facebook under Kimberly Banks Fawcett, but I do run a nationwide note closers group, which if you all are not in there, you should join. That's a great place to go and ask questions. Dave, as you see, is from JKP Holdings LLC, is in the chat box. He also has a Facebook group that's awesome. It's the East Coast. Dave, type it out. I'll never get all of the different names. East Coast Note Investors something. We all titled them differently. Feel free to advertise your group, Dave, is what I'm saying. Anyway, that is my phone number if you need it. And I say text because I'm not good with calls or voicemails. I have skills, just not that one. That's my website, inspiredcapitalgroup.com. That's pretty much it. Looks like nobody else has any other questions on the webinar. But if you are, lounging around at home, kicking back, eating a bowl of chips while you got your Netflix series going, and suddenly you want to know why you care if you say this note is secured, because you can't remember what I said, ask me on Facebook, shoot me a text, send me an email, whatever. I'll remind you. Oh, Dave put it up. East Coast Distressed Note Investing. Perfect. That is the name of Dave's group on Facebook. There's always a lot of other note investors around. And if you suddenly have a question, like I'm looking at an O&E here and I don't understand what this exception means. Does anybody know? Someone can talk you through it. Again, remember it's a legal presentation. You probably want to find an expert to ask that question too. But at least the person on Facebook can get you conversationally understanding what they're talking about. And I think that's pretty much it. It's 8:14. Thank you all for putting up with me for over an hour. I appreciate that. I hope the thunderstorm didn't get too bad. Looks like it might have passed. I might actually not get rained on when I leave my office. And that's pretty much it. Hope you guys have a good night. Thank you for joining us. Take care.